Good evening, everyone. So we have our class today on Contracts Act and basic concept clearing on your doubts, which unfortunately none of the students had sent during, like within the deadline time that was set in the platform. So, when just quickly, when we are giving you a deadline, please try to meet it and send in your doubts within those deadline period. Okay, so we have our faculty today, Tushampati Sen, and he is going to give us an overview on representation, warranties, and indemnities, and how to like the nuances on how to draft them in a contract. If you can take it up, Tushampati.
Sure. Hi, everyone. Good evening.
Hi, sir. Good evening.
Hi. So reps and warranties and indemnities become basically the foundation of every contract. And so as from a lawyer's perspective, when you're dealing with a contract, at a dispute stage, one always goes back to what has been written by the parties at the time of entering the contract in the representations and warranties and in the indemnities. So I'm just going to share a screen, which will just tell you, I've got a small, kind of a talking points write-up, which will help maybe all of us understand what I'm talking about. Just give me a second. Can you see the screen?
Yes, sir.
All right. So representations and warranties. So let me start with representations. So representations are usually, there are statements of facts, right? They're present and backwards looking. And they're meant to form the foundation of every commercial transaction that is being entered into by the party. So what is a representation? Representation is essentially to say that, let's say I'm buying a property. A representation would be to say, this is my property. So suppose the seller will tell the buyer, this is my property. And thereafter the transaction is entered into. So the representation is the foundation that I am doing this transaction with the seller, because the seller has represented to me that this property belongs to him. So representation is a statement of fact. For example, if I say that I want to enter into an agreement with an Instagram influencer who will be selling my product, or who will be basically pushing my product on his or her page. But I want an Instagram influencer who has a valid following. The representation made by the person will be, I am representing, or I do have a following of more than 1 million people, or I do have a following of more than 500,000. This statement of fact, which makes me want to enter into an agreement with this person XYZ, is the representation which forms the foundation on the basis of which this agreement is entered into. So a representation is nothing but a statement which is meant to persuade the other party to enter into the agreement. Now, the representations are all the facts as to why this person is the person you want to enter into an agreement with, or why this company is the company that you want to enter an agreement with, happens prior to the contract being drafted. You always have had these discussions way before you actually agree to enter pen on paper and do the deal. So, for example, in the influencer example, obviously that conversation has happened way before parties have even discussed commercials, right? So my discussion with the person, or my discussion with the seller of the property, has happened way before, and I've established the fact that he is indeed the owner of the property, or I've established the fact that this person indeed has a following of more than 1 million. Only then have I entered into this agreement. So we will also now see why representations are important in a contract, right? And why they hold an important position, because representations are always those facts which parties have already assumed or have agreed upon as being true in order for them to have entered into an agreement. Now, let me quickly get into the definition of warranty, and then we'll get into why they're different and why they're clubbed together. So warranty is nothing but a promise. A simple way of understanding warranty is that it is a statement as to what is present and what will be in the future. So often in many foreign law contracts, we often see the word warrants have been replaced by covenants. So covenants or warrants are basically promises, or are basically certain undertakings that the parties are giving to the other person for their comfort. So this doesn't go as far as becoming a contractual provision, but they're ancillary and in support of what the contract is being entered into. And when we go through the examples, I will point out what the warranties are and what the representations are and how they're different from a major clause of the contract. So, for example, if I say that the representation in the transaction involving a property is concerned is that this property belongs to me. That is a representation. And if I say this property belongs to me and post this purchase, none of my heirs will have any claim on it. The guy who's buying the property, for him, both of these matters. It matters to him that the guy who's selling me the property is telling me that the property belongs exclusively to him. It is also equally important to me that he is telling me that none of his legal heirs will come and file a suit against me tomorrow saying, no, actually, I also had a share in the property. But the representation here is that this property belongs to me. The warranty here is that none of my legal heirs will make a claim against it in the future. I don't know if it is clear, but when we go through the examples, we will I think be able to point out the differences better. Now, so therefore, if you see my fourth bullet, are representations and warranties different? Yes, they are different. Representations are past and present looking. They are statements as to what has been and what is currently going on. These are 99.9% of the time pure statements of fact. Warranties are to be understood as covenants. They're to be understood as undertakings and promises. They're mostly present and forward-looking. Now, a very big important issue is what is the distinction if there is a breach in either case? So if warranty is nothing but a promise, then a breach of a warranty gives you nothing but a right to bring a case of a breach of a promise, which means you get to come and say in a court of law or in any adjudicating body that this is the promise that was made to me in terms of this clause of the contract. Now, either hold him to specific performance. I don't know if you folks are aware of specific performance. Specific performance is that concept where you ask a court to pass a decree that they must be held to what they have promised under the contract. So the remedy for a breach of warranty is you come and ask a court, either hold them to specific performance, make them perform what they undertook to perform, or give me damages. Compensate me for the promise that they broke. That, in a nutshell, is what you can do if there is a warranty breach. Now, what happens if there is a breach of representation? And this is where it becomes interesting. So Section 19 of the Indian Contract Act says that where your consent is not free, the agreement or the contract is voidable at the option of that party whose consent was not free. And one of the grounds on which they have said that a consent may be taken to be not free is if the consent was taken based on a misrepresentation. So why is representation important is that if it is the representation, if it is the facts on the basis of which you agreed to enter into a contract, if that underlying fact is tomorrow shown to be false, you may be able to put your hand up and say, well, this is not the deal I wanted in that case, and be able to walk away from it. So in the case of the influencer, if after entering into the contract, even if the influencer has pushed my product on his or her page, if I find that the representation made to me, that is, I have 1 million followers, is false, and that person only has, say, 200,000 followers, I am able to walk away saying that this representation was the foundation on the basis of which I entered into the agreement with you. Therefore, I would like to treat this contract as void and walk away. And please refund my money, and I have no obligations towards you. So a breach of representation gives you a Section 19 right, which is to stand up and say, my consent was not free. My consent was wrongfully acquired. This is misrepresentation. I would like to walk away, terminate the contract, rescind the contract, and or accept the misrepresentation with the caveat that compensation will be paid to you. So for example, again, in the Instagram situation, I may look at the person and say, well, you're doing a great job, so I don't want to terminate this. But look, it's not reaching the people I thought it would reach. So please compensate me by paying me my money back, by paying me half my money back, or by giving me damages, or because now I will have to go to one more Instagram influencer because I want to reach so many people, you will need to compensate me for the cost I'm paying to that person. So whatever the compensation is, the remedy in terms of a representation breach is walking away from the contract by calling it void or seeking damages. I hope this bit is clear in terms of what is the consequence of a breach of representation and breach of warranty. Now the question is, in almost all contracts, we will find that reps and warranties, as we commonly call them in our language when we talk about clauses, reps and warranties are always together. We will hardly find a case where you have pure representation clauses and pure warranty clauses. There is no legal answer to this. The answer why we as lawyers have often clubbed it together is A, because it's time bound, and we as lawyers don't like to change anything that has withstood the test of time, but also because it is strategic. We must remember that we break things down into what is a representation and what is a warranty only when there is a dispute. That is when the parties are warring with each other. That is when lawyers really sit down and try and use a little scalpel to say, well, this bit is a representation, this bit is a warranty. But at the time of framing the contract, the goal is to get the deal done. And that is essential to understand why contracts are entered into and why they are drafted in a certain manner. The object at the time of entering into a contract is to record the understanding of the parties. Please bear in mind, we must always remember, much before a contract is entered into, the deal has actually happened. The parties, and more often than not, sophisticated business entities, sophisticated entities like companies, like artists, like sports people, whoever have been dealing with business for a long time, who have managers, who have experts guiding them, have always got the bottom line of the deal sorted before a contract comes into place. So the idea is in that contract to record as closely as possible what is it that the parties agreed to. And secondly, and very importantly, is to get the deal done. So the idea of not putting warranty separate from representations is twofold. One, it helps to sell the entire product much better. And when we go through a clause, I'll show how in the same language, we try to match a representation and a warranty together so that it is more palatable for the other side that is reading the contract. They don't have to, because when it's a representation, it's a statement of fact. You don't really need to go as closely. It's either true or it's not true. But when it's a warranty, and therefore it's a covenant, you need to be much more careful. So when it is clubbed together, and smart draftsmanship, a clever way of drafting will manage to kind of stitch a warranty into a representation in a seamless manner, it is much more palatable to the other side. It usually goes under the radar, and the deal gets done. It's not a situation where you're now talking about a warranty, negotiating about a small line which is ancillary to the major contract. For example, in the house buying situation, whether your legal heirs, how many legal heirs do you have? Whether are you undertaking that they will? Now that in itself is a protracted negotiation. You don't want to go through a protracted negotiation for something that's ancillary. You want to get the deal done. The second is, it's often very difficult to really segregate a representation and a warranty. And again, this will make more sense when we go to the example. But there is often a very, very thin line of difference. The minute it is a present-looking statement, it can be either. It can be a representation, it can even be a warranty. But a warranty sometimes, for example, when I say that I have all the licenses that are required to run a hospital, to run a restaurant, and they will subsist during the pendency of this agreement, it is very difficult to actually pinpoint and say whether this subsequent sentence is a warranty or a representation. Because if one has to argue representation, one will say it is a representation saying that these licenses are valid and maybe the tenure is such that they will be valid for the extent of the agreement. The other way of looking at it is that there is an undertaking being given that I will make sure that my licenses are valid during the subsistence of the agreement. So sometimes it is difficult to understand how one needs to really frame it. And therefore, it makes sense to put it all together in one bracket, which are statements of facts, which are undertakings being given, which form the foundation on the basis of which the contract is being entered into. The third bullet I talked about, and I will show you in the clauses, that we often couch warranties as representations, because as I said, a representation gives you a much greater right, which is to walk away from the contract. And yes, now the last bullet, when it allows you to frame the context of the agreement, representations and warranties are very, very important when you get into a dispute. So when we look at contracts, when as a disputing counsel, sometimes contracts come to me and parties say that this is not the deal I wanted. For example, I'll share a live example with you without getting into particulars. Recently, somebody came into a contract and said that my party was supposed to take an entire property on lease to run it as a hotel. Now, the question was whether the entire property was to be given to me or not. Now, nothing in the contract, surprisingly, talked about what is being given to the parties. We then looked at the representations and saw that the representations were all with respect to the entire property. It kept saying the entire property is available. The entire property is free of defects. The entire property is something that my party was interested in. And we used the representations to come back and say that the statements were made with respect to the entire property. And therefore, it was on that foundation that I entered into this contract. So today, this mischief of saying, well, the basement was never part of the agreement, or we never talked about the terrace, is not good enough, because the foundation on the basis of which I entered into this project was you talking about the entire property. So a representation and a warranty becomes the entire plinth on which the parties have entered into an agreement. And that often becomes an extremely important factor for us to consider when there is a dispute, as to understand what is the agreement that the parties entered into. Now, here is a simple clause that we had once negotiated and gotten through in a civil works and supply contract. So I'm just going to take you guys very quickly through these clauses. So this is a supplier's representation and warranties. And I'll read it. It says that the onshore supplier makes the following representation warranties to the owner, each of which is true and correct as on the effective date, so and so, so and so. And that will be continued. So please see now. And warranties shall continue to be true and correct throughout the term of this contract. Right? So now this is an undertaking being given. So the first bit says that he makes a representation which are below, and he says that they are true and correct as on the effective date. This statement that they are true and correct as on the effective date is a representation. It's a statement of fact. It is saying that as on the effective date, I don't know if you're aware, effective date means the date on which the contract is being entered into, right? So the statement is that each of these representations and warranties are true as on today. That is a statement of fact. And says, shall continue to be true and correct throughout the term of this contract. Here, the classical view would be that this is a warranty. The other view could be that this is a representation, because I am saying that I know that whatever I am now telling you will be true or will hold true for the while that this contract is to be performed. Now, either way, whether you take it in the classical sense or in the sense that it is a representation, the fact is this statement is extremely important for me, for me to be able to agree to enter into this contract. Right? Now, let's see what it has said. This A, it has been incorporated as a company under the Companies Act, is validly existing and has the power and authority to carry on business in India. This is a pure statement of representation, right? It has the power to enter into this contract and comply with its obligations under it. Does anybody have any view as to whether it's a representation or a warranty? No, I take it.
Representation.
Yeah, it's a representation.
Yeah, fair enough. Now, what's C? It has in full force and effect the authorizations necessary for it to enter into the contract.
Representation.
Well done. D, it has satisfied itself as to correctness and sufficiency of the contract price. So this is a representation. But now please see what it says here. It has satisfied itself as to the correctness and sufficiency of the contract price. Right? Now, change in price, or the fact that no, what you're paying me is actually not good enough, or market prices have gone up. So what happened after the Ukraine war, for example, is a lot of raw materials, the prices shot through the roof, right? So a lot of businesses, a lot of contracts suddenly became unviable. And people came to the contracting party saying that, look, the price at which we agreed to enter this contract is no longer viable. we can no longer work at it, let's renegotiate. If there is a clause in the contract which says contract price is so and so, you may be able to come and interpret it and say, well, the contract price was supposed to be so and so in the circumstances, yada, yada, yada. Now, please see what the cleverness of including this as a representation. What it means is, it is a statement of fact that this entity considered the contract price, thought it to be sufficient and correct, and on that basis entered into this agreement. So tomorrow, if there is a dispute, I can actually stand up and say, you represented to me that you like this contract price, that you're happy with it. If you're now saying that, no, actually, I wasn't very happy with it, it's a misrepresentation, and I should be able to walk away from this contract. There is no other reason why this should really be a representation. This should actually be just a pure clause in the contract saying contract price is this and parties have agreed to be as such. So here is where the draftsmanship and the end goal of protecting your client comes, or protecting yourself, whatever it may be, becomes important, and you try and couch certain clauses in the form of a representation. Now, please see E. It and its subcontractors have the requisite skill, experience, expertise, capacity, and capability to manufacture and supply so-and-so, and to satisfy and fulfill all their respective obligations and responsibilities under this contract. This is also a pure representation. But I hope you guys you folks see the cleverness in this clause. It is simply making it seem that you have represented to me that you have the wherewithal to handle anything that comes your way. Tomorrow, if there is a situation where you stand up and say, well, this is not something we anticipated. Suppose you're digging into the ground to build the foundation and you hit a rock. Now you suddenly need to bring in an expert who's going to blast that rock. Otherwise, you're not going to be able to drill down. So now you come back to me and say, well, I can't do it at this price. I look at this clause and say, well, you represented to me that you have the entire skill set to satisfy and fulfill all your obligations under this contract. If you hadn't represented that to me, I may not have entered into this agreement with you. I may have gone somewhere else. So again, the point of this deal was something else. It is obviously taken out of context. What I'm trying to show you is a representation and a warranty is a place where you do clever drafting. Of course, you do clever drafting everywhere in the contract. But this is actually that one zone where if you manage to push in obligations as a statement of fact, you build upon yourself a much bigger power to walk away. If the other party comes back at any point of time to say that, no, well, look, this doesn't work. You give yourself the right to claim damages, and you give yourself the right to say, well, this is fraud, therefore. You defrauded or induced me to enter into this agreement based on what you wrote here. Right? So similarly, the owner has his own representations and warranties, which I won't go through because they're all the same, except the last one, which says it shall, with the necessary assistance of the onshore supplier, as and when required, acquire permits, approvals, and or licenses for the project from the government instrumentality, which are required to be obtained in the owner's name, so as to enable the onshore supplier and the owner to perform their respective obligations under the contract. Now, what is this? Is this a representation or a warranty?
Representation.
Warranty.
So who's saying representation? Okay, who's saying warranty?
Representation.
Right. So in my view, this is a warranty because it is a forward-looking obligation. It's saying it shall, with the necessary, as and when required, acquire permit. So tomorrow, if it doesn't, one can only go back and say, you go and tell the court, you please make him acquire these licenses. And if he doesn't, pay me compensation. But it may not be treated as a representation to say that, well, he said he has it. Because it is saying here, I shall, as and when required, acquire these permits. So it is, in the classical sense, a warranty. Now, financing agreement, this is another agreement that we had done. When you enter
Just
into
one case, in case of this last point, wherever, let's say, where the contract prerequisite requires that there has to be certain approvals in place. Let's say a current recent example of a bullet train project where Japanese authority has said that unless and until all the land and is in the name of that particular company, we will not initiate the work.
Yeah.
So then doesn't, when the contract requires a prerequisite of a permission to be in place for a contract to be taken over, then in that scenario, will it not take the role of a representation?
No, that's a condition precedent. That's an entirely different issue. So what could happen is you may say in the representation that the land is in the name of the entity.
Correct.
And the condition precedent would say that the agreement becomes effective from the date that this person has a land in his name, or the land has been acquired in his name. So what we normally do, I mean, we're drafting condition precedents for large projects such as these, is we always build in a timeline. So we say within 30 days of executing this agreement, this person will be able to make the property in his name or whatever. And from that date will be the effective date. That is the date on which the contract becomes effective.
Okay.
And in the representations, we write that the title of the land belongs to this person as on the effective date.
Okay. Okay.
You see the stitching here, right?
Yeah. Yeah.
So you understand. So agreement is signed. Obligation to acquire land triggers from the date you sign the agreement, but nothing else in the agreement triggers until you've acquired the land.
Okay.
So now here is the financing agreement. Let's see what this section 12, which was in that agreement, says. It says the borrower, and of course, when you're doing a deal with the bank doesn't give you anything. It's the borrower who will be making all sorts of promises to the bank, right? So this is a one-sided representation. It says the borrower makes the following representations and warranties as of the date hereof, and as of the initial disbursement, which is a concept under that agreement, and each subsequent disbursement date, and as of each interest payment date and each repayment date. Such representations and warranties shall survive the execution of this agreement. What about this line? Is it a rep or is it a warranty?
Warranty.
Yeah. So again, here in the classical sense, it's a warranty, but I think this is one of those gray areas where it is maybe difficult to pinpoint and put your hat on it, right? But let's go forward. 12.1, this is a standard one. I'm not going to go through this. This is essentially what all agreements have, that you first give a representation that you're duly and validly existing under the law under which you are incorporated. You have the power and authority to execute and deliver all the documents that you are actually agreeing upon. And you have the power and obligation to perform your obligation. So any representation and warranty under any contract, you will require the other party to, and the other party shall require you to, first of all, establish that you're a lawful entity. Right? So if you're an individual entering into an agreement, you will say that you're a citizen of so-and-so country, that this is your valid documentation to show that you've been validly existing, that you're authorized and empowered to perform this particular contract. So for example, if there is a share purchase agreement, or if suppose you are entering into an agreement to buy someone's securities, and suppose there is a SEBI mandate against you, saying that no, you cannot, for the next 1.5 years, there's an embargo on you, you cannot deal in securities. The whole world is not supposed to know that. I mean, the whole world is not able to know that. So your representation to the first representation that the other party will ask of you, and that you should similarly ask of other parties, is you are legally entitled to enter into this agreement. Once that person says yes and signs on that piece of paper, tomorrow, if you find it to be untrue, you get to again use the concept of misrepresentation under section 19 and the whole enchilada, right? Now, 12.1.2, all acts and conditions and things required to be done, fulfilled, and all clearances which are necessary as of the date on which representation is being made or repeated for the purchase object, including importing so-and-so, there to offer the performance obligation on the transaction, have been done. Please see A, have been done, fulfilled, obtained, effected, and performed. B, are in full force and effect, and no such authorization has been revoked or cancelled, or an intimation or notice has been received that such authorization would be revoked or cancelled. Is this a representation or a warranty? B.
Representation.
Anyone has any other view? No, that's right. It is a representation, because the whole point here is we want this person to be able to say that none of his authorizations would be revoked or cancelled. But we don't want it to fall in the realm of a warranty. So we have put it in the manner that no such authorization and no intimation or notice has been received. So what happened in this case was, I'll tell you, the clause that came from the bank was, and that no such authorization shall be revoked or cancelled. It was very difficult for us to give that warranty. It was very difficult for us to make that covenant to say that, yes, we are undertaking that for the next 20 years, which is the term of this financing arrangement. None of my consents and permits will be affected. It's very difficult to make that statement. And the issue with the financing agreement is the minute you slip up, it gives the opportunity to the bank to come up and accelerate the debt, right? So here is where we stated we will write this, but we will only say that there is no intimation or notice today, which will help us which will make us make the statement that something will be revoked or cancelled. So we converted a warranty into a representation that we could live with. Is this something that is clear? That we would, yeah, all right. See, let's look at no contravention. I'll go through this very quickly now. Neither the execution and delivery, or nor by any obligor of this agreement and other transaction documents to which each such person is a party, nor the compliance with the performance or the terms hereof, nor the use by the borrower of so and so, contravenes any provision of applicable law. This we can understand it's a representation. Conflicts or is inconsistent with or results in a breach of any of the terms, covenants, conditions, or provision, or constitutes an event of default under any indenture, mortgage, so and so, to which is a party is bound to, or which they may be subject. Now, just one second. I'm sorry, I've read it very quickly. So until here, and you may read it, this is a statement of fact. It says that nothing here, my use of this money does not contravene any of the conditions of any indenture, mortgage, deed of trust, credit loan agreement, or anything of that sort. Right? But it goes on to say, to which the borrower or any other obligor is a party, or by which they or any of their assets is bound, or to which they may be subject, or results in the creation or imposition, or the obligation to create or impose any security interest upon any of the property or assets of the borrower of the. Now, this little phrase, may be subject, is an interesting one. Again, the point was to come back and say, this is where the bank tries to put in a warranty upon us. As on the date of the agreement, we can make this statement to say that, look, I am not in violation of any document. But the bank is not concerned with what it is today. The bank needs to protect itself for the next 20 years. So the bank comes and tells us, can you give us a warranty that you will not be, that none of this will violate any agreement that you enter into? It's impossible for any party to give that warranty for 20 years. So this small 3 words, that they may be subject, becomes enough for the bank to play on later on to say that you told us that you're not in violation of any document, or any document that you may be subjected. Right? So this is the way in which a warranty is couched in the form of a representation, making it palatable for us to accept it. Right? Now, lastly, of course, C, which says that will violate any provisions of the MOA and articles of association of the borrower. This, I think we're all now clear, is clearly a warranty, because we are now giving ourselves a forward-looking proposition, right? Just let me see if there's any, I don't want to take you guys through all this. I think it's becoming a little dry. Right. Now, let's have a look at events of default.
So, I have one question.
Yes, please.
So representation is a broader, has a broader remedy within it as compared to warranty. So if any if like in the previous case, if it is a representation, then what is the benefit of that may be put, which has been put by the bank? I mean, under representation, the bank has the broader remedy of either to terminate the contract or to claim for damages. So why would, that's my question. So why would they want to put a condition which imbibes like a warranty? I mean, they'll get the remedy within representation itself.
That's right. That's right. Absolutely right. So see, the point is, when you make me give you a representation that I'm representing to you that none of this will be in violation for the future. The idea is you must try and get a representation. What is a representation? As we discussed earlier, representation is nothing but the foundation on which I entered into the contract, right? So if there is a statement saying that I'm promising to you that the money that I will be using from you is not in violation of any of my documents and will never be in violation of any of my documents, it may be a warranty. It may also be a representation. Why? Because it is a statement saying that this money will always be used for things which are legal, or which always be used for things which are not in conflict with any documents. But an undertaking would be to say that I am undertaking to you that I will make sure that this money will always be used in a particular manner. The distinction is very negligible. You see, as I said, often it is very difficult to pinpoint which is a warranty and a representation. But the minute you're able to give it the color of a representation, it becomes a far more grievous issue. So the bank, for example, if it says that it's a breach of warranty, when it goes to execute its claim against me, the court will have to consider whether the breach was fundamental enough for the bank to actually terminate the loan. For the bank to say, no, you now give me my entire money back within a 14 days, or else I'm going to DRT and SARFACI and all that, right? So the arbitrator or the court may say that, yeah, look, the warranty he gave you, but it's not that big a deal that happened here. So you take some damages and move on with life, carry on with the loan. But the minute you're able to give it the picture of a representation and come back and tell the court that, look, this is the foundation on the basis of which I was willing to give him so much money. So the fact that this foundation is wrong, or that, that this representation turns out to be incorrect, he never intended to. See, the idea is for me to be able to argue tomorrow and say, he made it seem that he intended to use this money in a manner that will never be in conflict. But now it is very clear he never intended to use it. Therefore, my reason for giving him the money is gone. The court may be compelled to say, you're right. Therefore, terminate the agreement. The entire money must go back within 14 days. And it is often very difficult to give, say you've taken a disbursement of 3 crores. You know you have the next 20 years to give it away. But now if you have to just suddenly repay it within 14 days or 30 days, then it's a huge pressure situation for you, right? As compared to a 3-year window that you're looking at.
Okay, sir. Okay, sure.
Now, 12.3 events of default. I'll take you straight to 12.3.3. Again, it says that the statement is no event has occurred which has or will have a material adverse effect on the project or the borrower. Do you think this is a representation or a warranty?
Warranty?
Representation.
Representation? Warranty? What are we saying? Warranty. So we have one warranty. I heard a representation. I think, Shrutiji, you said representation, I think. So according to me, this is also a representation. Although this is a warranty couched as a representation, because what we are saying is no event has occurred, which is a representation, which is a representation, or will have. Now, this is where it may seem like a warranty, but actually the statement that I'm saying is no event has occurred today, which will have a material adverse effect tomorrow. You understand? Right. See, none of this is an exact science. I hope you understand. See, the reason why we as lawyers end up making some work for ourselves is because this can be argued in both ways. But the idea is you must understand the distinction. And as I said, the scalpel is taken only at the time when the dispute has happened. Otherwise, because often the warranty and the representation is so seamlessly intertwined, is why representation and warranties are clubbed together into one clause. I hope you understand why these are now put together. Otherwise, they could have always been put as covenants and representations, right?
So I think that we'll have is a strict interpretation of that adjusum generis, that your present circumstances are not such that it would have an impact in the future, is what
Yes.
Will take the characteristic of a representation, is what you are saying.
Say that again, please. I don't know why, how are you applying adjudum generis to this? Because
the earlier words are having a present thing. So you are, the interpretation goes like that the facts as it stands today, there are no circumstances that it will have an impact on the future. But any event happening in the future and having impact in the future, I am not giving any representation now.
So now let me just try and I see what you're saying. So let me see if we can.
Let's say an example, which means as the recent in some, of course, related to this COVID, which affected most of the companies, I think, in borrowing or execution of certain project. So 2 years before, there were no circumstances as a COVID which I could foresee that it would have an impact on the project later on. So this is talking about on the date when I'm signing the contract, there are no circumstances, but there could be a situation where, or an external factors which may affect, which may have an impact on the project but which I cannot foresee as on today is, I think, as a result, this is taking the color of a representation, is what you are trying to say.
Yeah. So now you're right. You're right. So now let's put some commas here and see if it changes the sentence. So we as lawyers love commas. I don't know if you know about this one celebrated case in Europe, where on the strength of a comma that was missing, $1 million was given as compensation, right? So let's see. So no event has occurred, comma, which has, no event has occurred, sorry, which has, comma, and let's say we delete the, 1 second. Yeah, let's say we delete the or. No event has occurred which has / will have a material adverse effect. Do you think the clause reads differently?
Yes, I think.
Yeah, will have will then future preposition.
Yeah, correct. So this is so if we had to put it in the form of a warranty couched as a representation, we would make a change something akin to this, which now makes which has occurred is the bit which is a representation. But the rule of the commas, as we are all aware, is that you read the portion in between the commas as omitted. It says no event will have a material adverse effect on the project. It becomes an undertaking.
Correct.
Right? Right. Lastly, I'll just read this new immunity. It was again an interesting clause when we negotiated it. It says the borrower shall not be entitled to and will not claim immunity for itself or any of its properties, assets, revenues, or rights to receive income from any contract, suit, or from the jurisdiction of any court, from execution of a judgment, suit, execution, attachment, or other legal process in any proceeding in relation to the financing documents. Is this a warranty or a representation?
Warranty.
Any other view?
Warranty.
Varunji, any view?
Warranty, sir. I'm also guessing it's a warranty.
All right. If one had to, are any of you lawyers, by the way? No. Okay.
Pardon, sir?
Sorry.
Pardon, sir?
Are any of you lawyers or law students? Who I was asking.
Yeah, I'm a third year law student.
Okay. So if you had to argue this to be a representation, would you be able to? I agree. This is a warranty because shall not be entitled to is clearly a forward-looking covenant, right?
Yeah.
But if I had to argue this as a representation, would we be able to? And see, there is a reason why a covenant is being put in the bracket of clause 12, which is a representation and warranty clause, right? So if I had to argue this to be a representation, could this be argued possibly?
Yeah, if since it's talking about entitlement, whether or not it will be, the future preposition is involved, though it's talking about entitlement. So maybe on that word itself, it can be called as representation.
Okay, fair enough. The way we have also argued a clause like this is to say that obviously this is a warranty, sure, but what is it that is being said to me? And remember, what is a representation? Forget, of course, it is present looking and past looking, and warranty is present looking and future looking. So we've all understood the distinction. But a representation, much more importantly, as far as the law is concerned, is that fundamental intention or that fundamental fact which caused me to enter into this agreement. So if I tell the court that, look, the borrower told me that he shall not be entitled to, which means he shall never be entitled. It will not be him claiming any immunity. It is on this understanding, it is on this representation by him that I will never be entitled to do this. I, as a person, will never have the legal personality to be able to claim immunity, is why I entered into this agreement. Can I argue this to be a representation? I'll give you the answer. It sounds attractive. We tried this, we failed. The court simply told us no, because the court said that every promise that a person makes is why you enter into a contract. That doesn't make every promise a representation. But it's what I'm trying to say is it's worth a shot. So the reason why somebody puts a clause like this into a representation is to be able to go to court tomorrow and try and convince that judge on that day to say that, no, look, this was a representation and it forms the foundation of my contract. Right? This is it. Now, this is an XYZ agreement. This is an agreement that I just want you to look at, and we'll have a quick discussion. So the reps and warranties, it says either party represents and warrants to the other party that as of forget this, it has obtained all government approvals, licenses, permissions, consents, and authorizations, and all corporate authorizations as necessary to enable it to perform its obligations under this agreement, and such necessary approvals, license, permissions are valid and effective. Is this a representation or a warranty?
Representation.
Representation.
That's right. So I had severe problems with this statement, with this heading, representations and warranties, especially when it's a one paragraph. So this, according to me, was very lazy drafting. When it was a clear representation, but it was only because the party or the team that was drafting this agreement was not willing to change the terminology. According to me, it's a pure representation, especially because the next clause was a clause on covenants. And when we see each party shall ensure that all approvals so and so, so and so, so and so will remain valid, this is a clear warranty. So this is one of those clauses where a simple representation and a simple warranty is being provided in the agreement. But because we as lawyers are very scared of actually changing the precedent, we have actually put it as representations and warranties and separately put it as covenants. Now the question is, do we need a clause on representations and warranties? Do we need a clause on representations? There are actually many contracts where parties is in whose in the example of buying a house, in whose interest is it to put down the representation that the house belongs to the seller in the contract? Is it in the interest of the seller or the buyer?
Yeah,
No.
seller. I think seller too. If in future it is known to the buyer that it is not the property of the seller, then he can sue the buyer seller. So yeah, stating that the property he owns the property is in the interest of both, I think. Maybe I'm
So I would not suggest it. If we were advising the seller, we would say never put representations regarding the property, because you don't want to record the foundation on the basis of which the contract was entered into. Of course, if the property does really belong to you, see, you should always state in the representations clause those things that you can live by. Now, for example, if you come back and say none of my legal heirs have any claim on it, and if you're saying that only because the other party is saying, nahi, mujhe kya pata, you must put it in, I don't know if your legal heirs will come, you put in a representation saying none of your legal heirs have a claim on it. I know many clients of mine who say, we'll put in a line, it doesn't matter. According to me, and I've often told clients, please shake hands with them saying that my legal heirs will never claim. But if you put it in contract, you must be sure of it. So it is the party putting in the money who may want to have the ability to walk away from the deal, who'll want representations put into the contract. He'll want those representations recorded so that tomorrow he can go and show the court that this is the foundation on the basis of which we entered into. Otherwise, it becomes a question of you having to be able to establish to the court that this was represented to me. A simple handshake and a simple statement is often not established. You can often not establish in a court of law. So, which is why we've often seen contracts where large European parties, when they're dealing with IPR issues, when they're dealing with intellectual property, they will pass only one small representation. They'll make one small representation saying, we are authorized to make this agreement. We are validly existing in the accordance with the laws in which I've been incorporated. And I'm stating that I have the power to enter into this agreement. They will often not want to venture into, I own this IP, I am telling you I own the IP, because in certain industries, the IP is so close to each other and so heavily contested that they often don't want to make that representation. They don't want to give the other party the right to stand up and say, you misled me. Also remember, a false representation not only gives you a section 19 right to walk away from the contract, it also often makes the foundation for criminal action. To come back and say, here is the fraud, here is where you induced me to give my money, and therefore there is a case of fraud or criminal breach of trust that can be made out simply from the terms of the agreement itself. So one has to be extremely careful while drafting a warranty or a representation clause. In my view, one must take legal counsel until one is very savvy with drafting in terms of what is being put in a reps and warranties. I can't stress this enough, because in disputes, we see the entire matter spinning on the basis of what has been written in a reps and warranty. All right, now coming to unless anybody has any questions, I'm moving on to indemnity. Okay, indemnity. So indemnity is nothing but a contract, right? And it's nothing but a contract. It's covered under Section 124 of the Contract Act. It basically says it's a contract where one party promises to save the other one from any loss that may be occurred to him by his conduct or by the conduct of some other entity or any event. So just for clarity, The difference between a contract of indemnity and a contract of guarantee is that an indemnity says, I will protect you if your losses caused to you by relying upon me or because you've been performing with me or for any act of mine. And a guarantee is where a person says, I will protect you if losses caused to you because of a third party. Right? So what is one is tripartite, the other is a simple bilateral agreement. So indemnity is basically a simple contract to make good the loss to compensate the other party for the loss. Now, interestingly, there is a concept of implied indemnity. All right. There is a tort. I don't know if all of us are aware of what tort law is, but tort is something which existed prior to contracts, right? Tort is something that we've adopted from the common law system. So there is an implied tort of there's a tort of implied indemnity, which says that when an act is done by one person at the behest or request of another person, and on account of relying upon this person B, person A suffers a loss, then there's an implied duty on person B to compensate A for the loss caused to him because of B. Right? This is exactly the concept of indemnity. The question, and by the way, this implied indemnity is very much accepted in Indian law. Right from 1938, the Bombay High Court has said that, yes, this is applicable in Indian law. And thereafter, it has been followed in a series of judgments. So the point is, if your contract is silent as to indemnity, you may still have the ability of going and telling the party, because of who loss is caused to you, that you need to make good this loss to me. Right? The question, therefore, is, why does every contract have a clause of indemnity? Or more or less, most contracts have a clause of indemnity. Or why do we as lawyers still tell our clients that you must have a clause of indemnity in your contract? If there is an implicit arrangement in the law, surely one doesn't need to have it in the contract. The answer is very simple. The minute you have another party stepping in to say, I will protect you for loss caused to you, if that person is not setting up, if that person is not standing up when the loss is caused to you, you need to take him to court. Now, it is not an evidence class, so I won't take you through the Evidence Act, but just enough for you to know, there's a section 91 of the Indian Evidence Act, which basically says that when something is entered into in writing, and I'll just read that relevant portion of 91. Yeah. It says evidence of terms of contracts, grants, and other dispositions. When the terms of a contract have been reduced to the form of a document, and in all cases in which any matter is required by law to be reduced to the form of a document, no evidence shall be given in proof of the terms of the contract. What does that mean? It basically says, when parties have reduced an understanding or an arrangement in writing in a contract and have signed to it, and are not disputing the fact that the contract had been entered into, then the term of the contract or what was agreed upon by the parties need not be established any further. It requires no further proof. This is also the reason why representations are often included in the contract. You don't need to later on come back and show that, no, this was what was told to me, or this is the foundation. It is in the contract. It is signed by the parties. It requires no further proof that this was what the parties had told each other, or this was what the parties had agreed to. So an implied indemnity is beautiful, and it is lovely where your contract is missing an indemnity clause. But in all cases, you must put in an indemnity because it requires no proof. You go to a court and say, he promised, here is the clause. Now please ask him to pay me the money, or please ask him to hold me harmless. Right? We'll go through the clause and I'll say other reasons why a clause of indemnity is required. But I hope you've understood why a written contract is better than what is implicit in the law, right? Now, I want to show one phrase that is there even in the Contract Act in terms of the illustration. It says indemnity is to make good the loss or compensate for the loss, right? Now, please note the phrase make good or compensate. Whereas we in all our agreements, right, the indemnifier will hold harmless the indemnified. Can anybody think and tell me what will be the distinction and why we must be doing this? Just take a shot.
Possibly hold harmless is more a wider term, because to make good the loss means you are asking the other party to do a specific performance and do it, and to compensate for the loss, that if you are unable to do it, you pay me money's worth, so that I can get it done from. But hold harmless would, I think, would take both the things into a consideration in all sense. Either you do it, or it also takes care about the compensation.
Okay. Any
More wider, and it take care of the both the sentences.
all right. Fair enough. Any other view?
I think holding harmless is simply not stating that the person is responsible, simply not blaming the responsibility or blaming the party as responsible for the action. So it is a wider, I think I agree to what they just said,
All
a
right.
wider protection.
Mr. Pathani, any view?
No, sir. According to me, also it just denotes a wider sense. I mean, hold harmless compared to make good the loss. It's a wider connotation. That's
all right. So all of you are right. All of you are, of course, right. Hold harmless is much wider than make good a loss. But there is another very, very important factor. When you say make good a loss, and there are actually lots of judgments on this. When you say make good a loss, it requires there to be a loss, right? So when the contract says that you will make good the loss that I am suffering, it means that I must pay out the damage to the third party, pay the cost for it, come back and show you my bill and say, look, this is the loss that was caused to me. Now you pay this. This person then has the ability of negotiating with you. Like, yeah, why did you pay so much? You were not supposed to pay so much. Who asked you to, hire the most expensive lawyer? You should have hired the second, tier lawyer. He would have done a great job. Why did you pay so much court fee? I'm not going to pay that much. Now you go to a court of law and say, I've already paid so much money. Now please ask him to pay. The court will then sit and decide, well, did you mitigate your losses? Did you actually see whether this much amount of loss was to be paid by you? Who asked you to settle so much? So now what has happened is you've gone out of pocket. You have paid out that loss. And now you're going to the other person, giving him opportunity of mischief. And you are now struggling to get monies to you, which you're out of pocket by. When you say hold harmless, this in judgments and in our experience, we have been able to negotiate and say, I am not supposed to be harmed. So the minute somebody has filed a claim on me, start paying my lawyer's fees. If there is any settlement to be done, you be involved and you pay directly to him. I am not to be harmed. So this is a very, very big distinction. And this one phrase, I'll tell you, in many cases of ours, has been an absolute boon to our clients. So what happens, for example, in a third party suit? So we were representing one engineering procurement company, and they were doing a construction through a subcontractor at a site where there could be floods, right? Now the subcontractor was supposed to set up a full a storage unit which would be sufficient to store all equipment, etc. They insisted on make good a loss. We kept fighting for hold harmless for the negotiations. And this was the one clause we fought tooth and nail, saying that we will not accept a make good a loss. We need to have a hold harmless clause. What happened was there were floods in that region after the contract was executed, thankfully. And one of the largest machinery slips out of the warehouse and goes crashing through a village. Right? Thankfully, no loss of life, but a significant loss of property. Now, my client, as the client who's been operating in that region, looks to me and says that, look, I can negotiate with all the village authorities. I can negotiate with the state and say, well, the loss that you're claiming that you want us to pay is not payable. Suppose the state and everyone else has come back and say, because of you, the loss cost to this village is 4.5 crores or 10 crores. And I can show that the loss cost is actually 3 crores. I should be able to fight with them and say, no, actually, it's not 10 crores, but 3 crores. But my client says, I've been in this region for so long, my goodwill is linked to this region, and I will be here for a while. So I don't want to negotiate with them. I want to say 10 crores, I will pay you full 10 crores. What that does is, I get to look at the other party and say, you promised to hold harmless. So I don't need to incur any loss for you to be triggered. So please step in. If you want to negotiate, you negotiate with the state. I am not negotiating. You negotiate, come to a price, pay the state. So what happens for my client is he gets to tell the state, I am with you. I want to be here for as long as possible. I am with the people. I don't want to negotiate on this. But look, this guy needs to pay, so you deal with him. If it was a make good or loss situation, I would have had to negotiate to the lowest possible number, come to a mitigation standard. Is everyone aware what mitigation is? Tejas ji and Varun ji, are you guys aware of what mitigation is?
Not fully.
Okay, so mitigation, very quickly, I'll tell you, is when loss is being caused to you, based on which you're going to seek damages from some other party, the law requires you to take all steps possible to limit the loss being caused to you. That is called mitigation. If you have not limited, the court will consider and decide whether you could have mitigated. And if the court finds you could have mitigated, it will reduce your compensation by that amount, which you could have mitigated and avoided. So here was a beautiful situation where, because of this one phrase, hold harmless, my client was able to put its hands up and say, I don't want to have my reputation or my goodwill tarnished at all. We are with the people of this village. Deal with that way. And make him pay 10 crores. You make him pay 10 crores, you make him pay 8 crores, you make him pay 4 crores. Whatever the state and they determine is fine. So what I'm trying to say, it has a consequence beyond the law. It is often, your contracts often, the power in the contract is not only about enforceability, but what all are you securing around with? Are you securing your presence? Are you securing your power in that region? That is what a beautiful contract should be allowing you to do. Now, here is an example of a typical indemnity clause. A and B, see, I've extracted the entire clause, but I'm not going to trouble you guys by going through the entire clause. What A says is that the onshore supplier shall take care of his own people. If there is any loss, liability, damage caused to your group of people, you're responsible. I'm not responsible if it has been caused due to your own actions. Similarly, owner says, if there is any loss caused to my people on account of my actions, I'm responsible, you're not responsible. Now comes the indemnity. The onshore supplier, and look at the language. Okay, the language in an indemnity clause is the most important. The onshore supplier hereby agrees to indemnify, defend, and hold harmless. Why defend? Because I want you to go and be the person who will talk to the affected parties on my behalf if loss has been caused because of you. Right? So, for example, this kind of a clause was useful for us for an auto. Am I running out of time? I think, yeah. If for an auto component manufacturing company, they got a certain unit, a certain small component of the engine manufactured by a subcontractor. That was fitted in the engine and that got fitted into the car. Now, that one unit malfunctioned, because of which the engine malfunctioned, because of which the car broke down. And this happened to a whole fleet of models for this one vehicle. So when this car manufacturer came to me and said, your engine caused the problem to me, I look at my guy and say, please explain. You come for these meetings and explain as to why it happened. I am not going to be talking to my car manufacturer. Now remember, my subcontractor has no contract with the car manufacturer. They are not related. They have no idea that both of them exist. But I, because of this clause, I'm able to tell him, you were supposed to defend. So please go and defend even in this meeting. Forget in a court of law where you're supposed to defend me anyway. You can defend me even in a meeting, right? So defend and hold harmless the owner from and against any and all claims, liability, action. Please now see, all claims. Liability, action, demand, judgment, loss, damage, cost. These all things happen after a court of law has adjudged against you. That is after an arbitrator or a court has said, yes, there is loss caused to this person because of your product. That is when liability, action, demand, etc. But we have included the word claim. Why is this important? So let's say the word claim wasn't there in this clause, right? What would be the consequence of that?
Any statement that the party would have made would be not defendable. Any assertions they would have made in future.
So I'll tell you very quickly, Shruti, the answer is the onshore supplier in this case hereby agrees to indemnify, defend, and hold harmless against all liability, action, demand, loss, damage, etc. Which means what? That he will come into play once there is a liability adjudged. Which means he would have been able to use this clause to say, I'm happy to defend you. Once there is a liability. A liability by law is when there is a acceptance of a claim, or when someone has imposed the claim on you. Which means I will come into action only when the court says so, or when you've accepted it. So the minute, that is the reason why we put in any claim. The minute there is a claim against me is when I get to trigger my indemnity. Do you see the importance of this one little word? Right? All right. In respect of personal injury, illness, or death, and in respect of loss or damage to any property incurred or suffered by any member of the owner group, so and so. Right? Similarly, it says, shall be responsible for any breach of the terms of conditions, any violation of applicable law. Here, this clause is not that important. In our context, it was important because we wanted to make sure that if any environmental standards are not followed, you will indemnify. Tomorrow, we don't want a situation where somebody comes, when the government authorities have come after me saying you violated CRZ notification, you violated pollution norms, you violated so and so, you fully indemnify me for that. Now it says, if there is any death or injury to any person or loss or damage to any property other than the property prior to transfer of title, you shall again indemnify me. This is again standard, right? Look at my owner's indemnity. This is what is known as a knock-for-knock indemnity. Whenever you see the language, this language is identical to the first paragraph here. This is what is, you may have heard the phrase knock-for-knock indemnity. A knock-for-knock basically means any loss caused to you or your group because of me, I'm responsible. Any loss caused to me or my group because of you, you're responsible. That is the standard thing. Here, again, as you will see, they also insisted immediately on the claims and the defend portion of it. We also included a party saying third-party claim, that if any third party is coming in because loss was caused to his village, loss was caused to his property because of you, you will protect me, right? All of this is fine. I want to bring you guys here, proceedings. This is another reason why indemnity clauses are in writing. So one, they're in writing because it helps you bring it into the realm of contracts. So you, along with the entire breach, you get to bring even your claim of indemnity before the arbitrator. If it was tortious, you may not have been able to bring it along with other contractual remedies. Second, we discussed under Section 91 of the Evidence Act, it's better to record your understanding so that you don't have to prove it. Third, and most importantly, this bit is in the interest of the party who is giving the indemnity. That you get to decide on a procedure. So see, on receipt of any notice, which would entitle any party to claim indemnification, the indemnified party shall within a reasonable time provide a written notice of the same, along with all documents available with it in respect of the said claim, specifying in detail the claim, the amount claimed, the date on which the claim arose, and the nature of default. Right? Then it says, it shall be in. Now, let me deal with this. Why is this important? Why did the indemnifying party want this? Because if any small aspect of this is missed, he gets to stand up and say, well, your notice is not complete. Please give me all the details. So this is another reason why parties want an indemnity clause in. You get to build in safeguards. It's not simple enough to pick up a phone and say, bye, come on, there's a claim against me, get into action. The point is, please detail it out. Tell me what is the claim, who has raised the claim, is the claim bona fide, what are the documents with it? That's important, right? Second part is that the indemnifying party shall be entitled to, but not obligated to participate in and control the defense of any such suit, action, or proceedings. What it does is the indemnifying party says that, all right, I'm responsible for your costs, I'll hold harmless for you. But the claim is against you. So if you tomorrow decide to appoint the most expensive lawyer for something that's trivial, that's a disproportionate reaction to the claim against you. And I'm suddenly paying the cost for the most expensive lawyer for the most expensive proceedings, which need not have happened. Similarly, let's say there is a claim against you and you're hiring an absolute novice and you're not taking these proceedings seriously enough because you're like, even if there's liability, how does it matter to me? This guy's going to pay it. I must have the right to step in and control the defense. I must have the right to ask you for all documents. and step in and put in my lawyers or my team or put in my expertise or my attention to the matter and try and salvage this situation, try and negotiate in a manner where I can get to the lowest possible number since I'm the one paying it. So this is another reason why the implied indemnity has no such obligation, has no such right of the indemnifying party to step in at the stage of adjudication. It only has a right to step in as subrogation once the cost has been paid. So it is for things like this. And say, for example, here the parties will also agree that if you fail to mitigate, I will not pay. Right? So an indemnity clause therefore allows you, gives you the freedom to put in safeguards and to put in triggers. And again, it comes down to clever draftsmanship, again comes down to your ability to negotiate, and again comes down to pushing in small words within large sentences, which will help cover. So as we saw, the smallest of words of claims changes the trigger point, right? I think that's about it as far as
this last clause was in the support of a party which is indemnifying the loss, means helping the it is helping the indemnifier.
Yes.
Means if you are representing the indemnifier, then this clause would help the indemnifier.
Yes.
Per se.
Yes.
And one more thing, whether the damage would also include damage to, let's say, reputation, is that can be indemnified? Is suppose
Yes,
suppose I subcontracted a certain thing, and the part of it was subcontracted, and in the because of that it has caused that party has a small name, but overall branding goes of mine.
Yeah.
So he will compensate me for the loss occurred, but in an overall, it has also harmed my reputation, so that no further contracts would ever come to me. So whether indemnity clause can also include damage to the reputation, or whether it would not get covered.
So we as lawyers, so when we use the word loss, there is no definition of loss. So the ability is to be able to say that loss means financial as well as any kind of loss, reputational as well, right? Now, I'll give you an example. Recently, we did this matter where, one party, there was a confidentiality agreement and there was an agreement to deal with sensitive information. And one party leaked it, causing my client's name to come in the papers everywhere, right? We immediately rushed and said, well, you need to indemnify us because of you, my name is everywhere, has a huge reputational loss, etc. What was argued by the other side, and I still don't know what the arbitrator will eventually hold, but I was quite impressed with that argument, I must candidly confess, is the other party came back and said that ever since that news has come out, your share prices have gone up. You've actually come in more and more interviews. And I know for a fact that 2-3 entities have now reached out to you for the same agreement. So there is no loss caused to you.
Okay.
So what I'm trying to say is all of this is a creature of contract. Correct. You can put whatever you like to. We often put it nebulously enough for us to be able to say loss means this and also means that.
Okay.
But often if you don't specify, you have to show a loss. Otherwise, it's going into into a paradigm of gain, and therefore you're out of your indemnity.
Okay.
Right. So that's about it as far as I'm concerned for reps, warranties, and indemnities. Unless there are any further questions, I think there was some question that I received. I could open only one of them, which was with respect to witnesses and condition precedent and subsequent. I can move to that if there are no further questions.
Yeah. I think one question from the video which I went through, I couldn't post the queries in that thing, but one thing related to this arbitration clauses. So when there is an arbitration clause, it is always essential to first exhaust the remedy for an arbitration and then only move to a court, or either party can ignore an arbitration clause and can move to the court directly, or first I need to exhaust that remedy of
It's not a question of exhaust. Once there is an arbitration agreement, there is no ability to move to court. See, the Section 8 of the Arbitration Act makes it mandatory for any court who's hearing the matter to see if there is an arbitration agreement to necessarily refer the matter to arbitration. So all courts, except your writ courts, which are constitutionally protected, are enjoined, are basically prevented from exercising any jurisdiction once there is an arbitration clause in play. There is no question of exhausting that remedy. That is the only remedy you have. Once your arbitration award is given, you may challenge it in terms of a Section 34 before a court, but that's an appeal, and that's not that's not a trial. So therefore, your evidence and all will all be kind of done by the time your arbitration stage is there. Only exception to this is writ court. So that's why often when there is a dispute with a public sector undertaking or a state entity, where you may have an arbitration agreement, you may still prefer to go to a writ, because your constitutional rights cannot be kind of whittled down by an agreement. But that's a different ballgame. That's a different issue. So shall I take up those two questions, which were on condition precedent and subsequent and witnesses?
Yes.
Right.
Sir,
So
I have one question.
Sorry?
Sir, I have one question.
Sure. Yeah.
So, sir, in the indemnity can be used for if there is a breach of representation warranty also?
Yes, of course. Of course. So again, as I said, it's a matter of contract, right? So you can always put in a clause saying that if there is any breach of any of the representations made in this agreement. So by the way, it's a very good question, because in all contracts which require an IP. So for example, if someone is giving me a specified IP based on which I must design a machine, and the representation made to me is that this is my own IP, I'm not infringing on anyone. So tomorrow, if I make a machine, no third party is going to come to me and say, hey, you copied my design and you made a machine. I take a representation from this person saying that, look, you represent to me that it's your IP. He says, I do. There is something called an IP indemnity, which is nothing but an indemnity, but specified to the IP, where I come back and say, if tomorrow somebody brings a claim against me saying that this is infringing their design, you will hold me harmless. Now you fight that person and show why this is your design. You fight that person to show why this was not my infringement or whatever it is, that it is different. But that is certainly an IP that you can, an indemnity that you can bring in specifically for the representation. An indemnity essentially.
And sir, what will happen if that indemnifier loses the case?
Sorry, say that again.
What will happen if the indemnifier loses the case? Then IP indemnity only, I'm saying.
No, so see again, if he loses that case,
because I have utilized his IP, thinking that its IP is his. Suppose now he loses the case and third party wins.
Yes. So now what happens? So now the third party's claim against you is finalized. So the third party will be able to come back and say either stop him from making any production and or make him pay compensation to me for having infringed upon my IP. Correct? In the second scenario, you look to your indemnifier and say, please pay that money to him, which this court has adjudged in his favor. Secondly, for me having to dismantle all my equipment, all my machinery that I made for you, here's the bill, here's the cost, here's the future loss of profit, please pay me my money. So again, it's a question of contract. It's a question of what all are you covering? How easy are you making your claim process? Remember, the indemnifier is also a savvy commercial entity. He's equally going to try and build in safeguards for himself. And it's a question of what are you eventually agreeing upon? And insurance that you take, your accident insurance, your fire insurance, your theft insurance is nothing but an indemnity, where one party is saying, upon this event, I will pay you money, provided you give me proof that this has actually happened because of this reason, blah, blah, blah. Does that answer your question, sir?
Yes, sir. Yes.
All right. Lovely. So now, we don't have much time, so I'll quickly just touch upon condition precedent and subsequent. Condition precedent is, as I think I just touched upon in between, condition precedent is a condition or a series of triggers that one has to meet, series of milestones one has to meet in order for the agreement to become effective. If those milestones are not met, then you get to walk away from that agreement, right? So for example, in a case where we were dealing with someone who produces turbines, the condition precedent was, you will clear the way to that site for my large trucks to come in. Until you've done that, there's no point me starting to work, because I know I will build this entire turbine, but it will never reach your site. So the fact is, the man, until he could actually tell me and give me picture that this road is now cleared, my contract was treated as non-effective. So nothing, no price terms, no liquidated damages, no time is of the essence came into play until that condition precedent was met. The one important thing to know practically is that once you set up a condition precedent, always set a timeline. Because what happens is, if you leave it open, that even for 2-3 years, you've suddenly in your mind planned your resources for a particular project, but it is never becoming effective. So you give yourself 1 month, 2 months, 6 months to say this condition precedent shall be achieved within 6 months. If it is not achieved, contract automatically terminates. We get to walk away. So that is what a condition precedent. Condition subsequent is something that you are putting in as a condition after the contract has become effective. Usually we see it in transfer of property matters. There's in fact even a section 29 of the Transfer of Property Act, which says that if there is a condition subsequent, for example, if I say that my property in a will devolve upon my wife. If my wife marries, this property then devolves upon my mother. This is the condition subsequent. So after the contract has become effective, after the property has gone to my wife, if there is a trigger event, then there is a different treatment that we agreed upon in the contract. That is what a condition subsequent is like. Now, very quickly on the witness issues, no, the Indian Contract Act does not require any attestation. It does not require any witnesses. There are certain acts like the Transfer of Property Act, I think talks about attestation. I think Section 3 of the Transfer of Property Act, I have it here. I think Section 3 of the Transfer of Property Act defines attestation and says those documents which are required to be attested must be attested by 2 witnesses, right? Section 68 of the Evidence Act says there are certain documents which must be attested. For example, a will. A will, if not witnessed by 2 people, is an invalid will. A mortgage deed, if not witnessed, is an invalid mortgage deed. Those are the deeds where a witness is necessarily required. And in terms of Section 3 of the Transfer of Property Act, an attestation means 2 witnesses. The Indian Contract Act does not require any witnesses. So a contract does not lose its legal sanctity merely because no witnesses have signed it. But we always get witnesses signed, because if any party comes back and says, well, I never signed this, my signature was forged, we get to present 2 witnesses to say that no, I was there when the witnesses was when this guy was signing it. Why is this important? Because once we are able to cross the threshold that this contract was indeed signed by you, Section 91 comes into play and says, now nothing else in the contract do I need specific proof of. So which is why you always want to put witnesses, so that you avoid this threshold issue of whether this contract was actually ever signed by this party or not. Right? So I hope that answers these 2 questions as well. I think that's all the time we have, folks. I hope this was useful.
And so same is the case regarding notary as well. I mean, it is also not mandatory under the law, but for the sake of evidence, just we notarize the documents.
Yeah, notary for contracts is simply to show that there's a public entity, there was a third party who saw these parties be present and they signed. That is an evidentiary value. Although some documents again require attestation, those documents in specific acts and statutes require it to be notarized. For example, if you're providing a first copy of something, deed, etc., sometimes it is required to be notarized.
Okay, sir.
All right. That's about it.
Hi, thank you for the class. I hope you guys all had learned and taken away a lot from this class. So thank you, Dishampati, for giving this wonderful lecture and taking us through all the clauses of indemnity and representation.
Sure,
and guessing it will be clearer for our students now, the concepts of it and how to draft it. Okay. And students, please complete your assignments. The next classes on drafting and LLP. The videos and assignments will be live. So please go through them and submit your assignments, because all your live classes are going to be based on your pre-class assignments that you are going to submit. So it's a request that please do complete your, complete watching the videos and submit the assignments. Okay. Thank you. Happy weekend, everyone.
Thank you. Bye.
Thank you. Thank you,
Okay,
sir.
thank you, ma'am. Thank you, sir.
Thanks.